He kept telling me his case was worth $10 million. $10 million. We were trying to have a settlement discussion, and I kept telling him, I'm sorry, I don't think your case is worth anywhere near that. What happens then? What happens when we try to have settlement discussions when my client has unrealistic expectations about the value of his case? Would you like to learn the answer? Come join me for a walk near the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, my client brought a lawsuit against a number of doctors and a hospital, claiming that they caused him significant harm and injury as a result of their carelessness. Now, the case has gone on for 2 years. Discovery has finished, and now we are on the trial calendar. We are waiting for a trial date. During the course of this waiting period, I have a conversation with my client. Prior to having this conversation, the defense attorney called me up and said, hey, listen, we're interested in trying to negotiate this case. Are you willing to talk? And I said, yes, we are willing to talk. Now, before we went any further, I needed to have a conversation with my client to determine from him what he would be willing to accept and, importantly, what I think the value of his case was. Now, do you think I came right out and said, hey, Mr. Jones, tell me what you think the value of your case is? The answer is, no, that's not what I do. And that's not the appropriate strategy. The better strategy is to explain to the client what are the risks of going to trial. What are the risks of accepting any settlement offer? What happens when they make a settlement offer? Why their initial settlement offer is going to be a lowball offer, and why their initial settlement offer is in all likelihood going to be immediately rejected. I discuss all this with my client, and it's important to discuss with him the risks, benefits, and alternatives to going forward with a settlement or going to trial. You see, the reality is that nobody really talks about is that when you go to trial, you have no idea, no matter what type of case you have no idea what a jury, 6 members of the community in New York, are ultimately going to do in your particular case. You don't know, I don't know, the defense lawyer doesn't know, the judge doesn't know. It's an unknown. As we go to trial, and now every single day is going to be different. There will be some days at trial where you will think that you are on top of the world and are winning your case. There will be other days where it will be just the opposite, where you think your case is going down the drain, the defense is on top, and now you want to do everything possible to try and settle your case, to get out of it quickly, to try and resolve and try and solve your matter, walking away with something. It is a gamble to go to trial. Why? Because you don't know, we don't know what the ultimate outcome will be. You could have the best case in the world. You could have the best experts in the world. And a jury could come back and say, sorry, Mr. Jones, we don't think we believe you. And we don't think you're entitled to receive a dime. As a result of that, they throw you out of court without anything. On the other hand, you could have an okay case, a questionable case. They believe you. And now they give you a substantial amount of money as compensation for all the harms and losses and damages that you incurred. So now getting back to my client's conversation, he kept telling me that he thought this case was worth $10 million. And you know what I said? I said, what basis do you have for determining that your case is worth $10 million? And now he began to rattle off a list of other people he heard about having cases and their settlements. Not anyone who actually went to trial, not anyone who had a similar case, not anyone who was in the similar county or similar age or similar injury. Rather, he had heard that somebody in his neighborhood had brought a lawsuit and they had gotten X number of dollars, and because of that, his injuries in his mind were so much worse than this other person's injuries. So therefore, his injuries must be worth an exponential amount more than what he heard about with this other person. And he continued doing that for a number of other people that he was reciting, that he was basing his opinion on, about why he thought his case was worth $10 million. And in response, I said to him, that's very nice, but it's all anecdotal, meaning he has no basis, no evidence, no factual support, no legal support to show that his case is really worth $10 million. Now, why is that important? It's important because my client had this clear perception that his case is worth so much more than what all these other people that he heard about, that they received settlements for. I said to him something very important. I said, listen, when deciding and evaluating the value of your particular case, we take in endless amounts of factors, such as your age, how your injuries have affected you on a daily basis, which is going to be different for every type of case, for every type of person. I said, where your case is venued is extremely important. Is it in the Bronx? Is it upstate New York? Is it in Brooklyn? Is it Manhattan? All of those factors make a huge difference. I said, did this affect your ability to earn a living? If it didn't affect your ability to earn income, then guess what? Then you're only focusing on pain and suffering, what we call non-economic damages. And that is variable. If, in fact, you lost, let's say, $100,000 a year for the last 3 years, and you're no longer able to do the type of work you did for the foreseeable future, great. Now we can actually calculate how much money you have lost in those past years, how much money you were likely to earn in future years for the remainder of your life. And we can do that using someone called an economist, someone who understands the value of money. So without having that type of damage, the value of your case drops significantly. And there were other factors as well that my client did not consider. And by the end of our conversation, he finally acknowledged to me that, okay, my case maybe really isn't worth $10 million. And I said, no, it's nowhere near worth $10 million. It has a significant value, but it is not what you originally perceived it to be. Now, why is this important? It's important because when we have settlement discussions, it is critically important for me to share with you my opinion, my experience about the value of your particular case. We are aware and we know and we can do research many times to see if there are similar cases out there and what they have settled for. Now, that's not always possible because many times the insurance companies try and inhibit the publication of these settlement values, meaning they don't want the attorneys who represent injured patients to disclose what they settled a particular case for regarding a particular injury. Now, why don't they want to do that? It's for self-preservation. They're trying to protect themselves. Now, you may be thinking, wait a second, what do you mean they're trying to protect themselves? Here's what it means. If we settled a case for, let's say, $10 million involving a failure to diagnose cancer case, now, if we went ahead and publicized that, now everybody in our neighborhood, everybody in our community, everybody in our state would know that we were able to settle this type of medical malpractice case for $10 million. So let's say an attorney in another law firm also had a failure to diagnose cancer case, but that person was much younger, but that person had significant lost earnings of $1 million a year, but that person had other mitigating factors that allowed these injuries to be worth even more than what we had settled our case for. So now it turns out, lo and behold, that they have the same insurance company that we were dealing with in our malpractice case. Now, can you imagine the plaintiff's attorney coming to them and saying, hey, listen, Oginski settled his case for $10 million on a failure to diagnose cancer case. Our case is so much worse, and let me tell you why. And now he rattles off a list and explains exactly why he believes that his client's case has a greater value than ours does. And now, what is he doing? He is leveraging our case and the value of our case against his own client's case with this same insurance company. And now the insurance company is going to be put in a very difficult position to say, sorry, we don't believe that your injuries or your client's injuries are worth anywhere near what you claim them to be, regardless of what Oginski's client's case settled for. That's why they don't want to go ahead and publicize those settlements, because they don't want other attorneys to use similar cases and similar values when negotiating future cases. That's the secret behind why they don't want these cases publicized. Okay, so getting back to the title of this video, my client was adamant that his case was worth $10 million. By the end of the conversation, he finally understood why his case did not have a value of $10 million and why he was becoming more realistic as our discussion progressed. So why do I share this with you? I share this with you because it's so important to understand what goes on behind the scenes. Now it's time to talk settlement. Now you have to have a realistic expectation of what the value of your case is. And if the defense comes back with a number that either approaches or exceeds that realistic number, now we have to have a very serious conversation about whether or not to accept that particular offer. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.